get this thing started here. So, a couple quick notes before we start this panel discussion. First and foremost, I just wanted to let everybody know that's here in the audience today. I'm sure a lot of you guys, I'm hoping that a lot of you guys will have questions this evening for our panelists. So, if you do, my colleague Jackie, raise your hand, Jackie, is back there. We have a microphone set up. If you guys have questions for our panelists, just go see Jackie. There will be plenty of opportunities. If there are any burning questions, feel free to ask them. So I will start with that. Second, I will preface this conversation by saying that the whole goal of this conversation is just to have an open and honest dialogue about the state of beer, really, in Massachusetts, specifically as it relates to some of the legislative efforts that I guess are afoot in 2017, and some of the things that traditionally over the years have happened between brewers and wholesalers, specifically as it relates to franchise law reform. So that is the goal. That's what we're hoping to achieve here, and that's why we've invited representatives really from, hopefully from both sides. Rob Burns is the president of the Brewers Guild, also the co-founder of Shift Brewing. So he's here to hopefully shed some light on what the plans are in 2017 for brewers, what they're looking to accomplish. Also give some perspective about what it's like to operate a small brewery in the state of Massachusetts. John Connell is, as I mentioned earlier, a Boston-based alcohol attorney. He runs his own practice. He works with a lot of different businesses across all three tiers. So if anything, I look to John as sort of the mediator here. And then Bill Kelly, as you guys I'm sure know, represents the Beer Distributors of Massachusetts. Has worked alongside the ABCC for 23 years? 22 years. And it has obviously been around the beer scene for quite some time. So thank you guys for joining me, and I guess let's dive right in. So a lot of what I want to talk about are some issues that I've been obviously writing a little bit about, reading a ton about. I guess a quick shout out to the Boston Globe. They've been covering some of these issues quite extensively. They've had some very good coverage. So I don't know if that's Dan Adams or who else, but they've been doing some great writing and reporting on these topics. So let's kind of kick things off, and let's start with licensing. I know that there's been some talk about license reform, permitting reform. Really, it kind of started with this statement of overhauling all of Massachusetts alcohol laws and a task force that was going to be created. So John actually just sprung this on me and said that earlier today he received some information about the task force that is being created in Massachusetts. So I kind of want to start there. John, what's the latest on the direction that the Treasurer's Office is going to take with this task force?
Well, thank you, Chris, for inviting me. Ripped from the headlines, I talked with the Treasurer's Office today, and as some of you may know, they're convening a task force to look at all of the alcoholic beverage licensing laws in Massachusetts from top to bottom. This has never been done since Prohibition, and it should be quite a feat for the Treasurer's Office to look at all of the laws and see which ones need to be amended and which ones should stay. According to the Treasurer's Office, it will be an autonomous body, completely free of all control, including the long reach of Bill Kelly and the wholesalers and the brewers. It'll be completely autonomous. There shall be 5 to 7 people of learned background, perhaps retired lawyers or retired judges or people in the industry. Bill, as a partisan, probably will not be picked for this commission, but he may be. The commission will be ongoing for perhaps a year. And it may not be rolled out for another several weeks or maybe a month from now, but it could go for a year. And then look into recommendations that they shall make to the treasurer's office, and the treasurer's office can then make changes with the ABCC. With regard to changes in the law, that will require a change with the legislature. So they will need to get a legislator to carry the water on prospective changes, and there may be the fight between lobbyists. This 5 to 7 people group is apparently going to be broken into subgroups. They're going to research manufacturers. They're going to research the ABCC. They're going to research filing fees. They're going to research every issue that we now know in liquor licensing. They intend to be volunteers and not paid. Because they're going to devote so much time, as I said, they may be retired people as opposed to people from the industry. If I may. The group is not yet complete. It's very interesting who they may appoint. We all may know some people, or we may not know all the people. Bill is one of the foremost minds with liquor licensing in the state of Massachusetts. I don't think will be appointed, but he may be. You never know. They're at the current point trying to identify the right people. These people need the capacity to navigate the very complex rules of Chapter 138 and all the case law that's come before it. The industry members may or may not be part of this task force. In other words, it would seem relevant and important to have a couple of members from the wholesaler tier, from the brewers tier, from the retailers tier, but that's not the way they're going to do it. Such a group would be 30 or 40 people large and probably be bogged down in infighting. So it's going to be a lean 5 to 7 people machine. When they're done, they're going to make a number of recommendations to the treasurer, and the treasurer can then make recommendations to the legislature. At that point, the legislature may be able to be hidden, in a sense, behind those recommendations without suffering the union protests and the various particular interests of various tiers, and may go along with a very learned academic request. It may be 6 months where they recommend low-hanging fruit, so to speak, easy solutions to easy problems, before they get to the meat of some of the disputes, like the franchise law here in Massachusetts.
Awesome.
What?
We have one more page of notes, I think.
Hold on, I got one more page. The ABCC itself will be under review. This learned commission will make recommendations as to how the ABCC may change the way it interprets the laws, the degree of flexibility that it has to interpret the laws, and its composition, which is a very interesting thing. Bill used to be the general counsel for the ABCC, and I'm sure this is anathema to Bill. Apparently, this summer's case of Neshoba Valley Winery, which I was the lawyer for the plaintiff, was the tipping point. What the ABCC and the treasurer and the governor don't want are any more short-term fixes to 138, where some crisis arises, they change the language, they add a sentence, or they delete a paragraph. What they want is a top-to-bottom look at the law. And that's what we may have come in 2018.
So essentially what you're saying is that we can't expect any meaningful reform next year.
I believe the deadline to introduce bills into the legislature is late January of next year, so it would be too soon. The Treasurer's Office is very aware that rewriting Chapter 138 is a Byzantine task. It's navigating the Amazon. It's reading hundreds and hundreds of pages and understanding how one section, if you amend it, may affect another section. So it's a very complex endeavor, and the people, the 5 to 7 people who are appointed to this commission, are going to be superstars in the effort they have to put forth. So I don't see anything happening for next year.
Yeah, I know that firsthand. I was trying to read through it this weekend, and it will take quite a while. There is some complicated stuff in there. So that's good to know that we heard about this task force. We heard all summer long that they were putting it together, that they were going to look at the alcohol laws in Massachusetts, and we hadn't heard an update. So thank you.
One last comment. They do intend to have public comment as this task force moves ahead. They want to hear from the various business entities and the industry people, and they're going to have meetings, and they're going to solicit public meetings and public comment. And at that point, the industry itself, the wholesalers, the retailers, and the manufacturers will be able to advocate their positions. But the commission itself is supposed to be beyond reproach.
Got it. So let's talk about the licensing, which I know is going to be a big part of that task force. And let's talk about how some of the breweries are operating in this state. And I'll start with Rob. Clearly there seems to be some issues with the way that the permitting process happens, the way that breweries are required to register as businesses that can manufacture beer in this state. And if you go just sort of look through, it becomes quite clear that the farm brewery permit is really the preferred permit for brewery operators here in Massachusetts. That also comes with the lowest fees. The farm brewery permit has the lowest fees associated with it. It gives you the most advantages. But there are some potential restrictions there. So, Rob, from your point of view as a brewery owner, from the Guild's point of view as a representative, as the president of the Guild, how would brewers like to see some of the permitting issues change in the state of Massachusetts? Are they working currently? Are they not working? And how can they be fixed, or how can they be altered to have a better system for licensing breweries in the state of Massachusetts?
Sure. So I think right now we have a kind of a confusing mismatch, and I think you've been quoted in the Globe as kind of saying such that over the years we've piecemealed a bunch of laws together and gotten something out there, and the industry has changed so dramatically that what used to be the industry is not what it is today, and the licenses haven't kept up with that. I think the farmer brewer is the preferred license in Massachusetts because it gives you the most amount of privileges. It doesn't give you unlimited. Like, for example, you can't serve hard alcohol, but if you had a brew pub license, you could potentially do that. I think what the Guild wants to see is just a clearer understanding of the rules, a clearer, easier process to make sure that everyone can get what they want for their business model. And we don't quite have that. We've all kind of figured out how to navigate the system, but it's kind of confusing.
Is it working? Is the system working?
I think, again, we figured out what works and what doesn't work and how we can work within the system, but I think it's far from perfect, and there's some work to be done.
Bill, how would wholesalers like to see brewery permits issued in the state of Massachusetts, specifically as it relates to the business that you guys are in, which is distributing, or the business that wholesalers are in, which is distributing a lot of these products? Is there a more efficient way that breweries can be licensed? If the way they were licensed changed, how would that impact the way you guys operate, the way wholesalers operate?
I lost track at 5 questions.
Thanks, Bill.
But we'll take them one by one. First of all, thank you to Jack Sabby for hosting this event, and thank you to Chris for inviting me to be part of the panel. As Chris mentioned, I am Bill Kelly. I am no longer the general counsel for the ABCC. I've been out of that in full recovery for 3 years now. And thank you all to the breweries who are assembled here for making the great beer that you have, particularly the wide selection that Jack Sabby has available for us to enjoy, along with some great pizza. Which question of your 5 questions would you like first?
Do you feel that the way breweries are being licensed in the state of Massachusetts is working? Is the system working? And if so, great. If not, how would wholesalers like to see it altered or changed?
Well, I don't know that the Beer Distributors of Massachusetts have a position in regards to the licensing process that breweries must go through in order to become an eligible seller to a distributor here in Massachusetts. The distributors recognize and we respect that is the province of the legislature with all their broad-based discretion. Certainly we are very aware of the various proposals that are made each and every year for changes in the law. We review them. That's my job, is to identify and review them along with all the legal advisors to see what the change is, what effect it will have, and is it something that we can support, or is it a proposal that it may have unintended deleterious consequences. Certainly as far as the efficacy of the current system, the proof is in the facts of how many licenses are operating now here in Massachusetts. I think at last count there were well over, 135 operating. They have a complete spectrum of choices of what type of business they want to operate, and the type of business you want to operate is going to drive the decision about what license you want. Every license has its virtues, and it also has its limitations, including a beer distributor license. So no one gets it all. And I think there are balanced and reasonable limitations on every license and scope of permission of what to do.
Sure, and I should also clarify that 122 total permitted breweries in the state as of October 4th. Those are the only numbers that I was able to pull prior to tonight's event. So 122 permitted breweries, 91 farmer brewery permits, 7 manufacturer permits, and 25 pub brewery permits. And it would be easy to just look at those numbers and say, okay, well, great, craft is growing, it's up X amount, and look at how wonderful it is. But really kind of diving into who those businesses are and the types of businesses that they're representing themselves to be, I think kind of paints a little bit different picture. You have farm brewery operators that are, operating with that license so that they can sell direct to consumers. You have pub brewery license owners who are not serving any food at their establishments and have large manufacturing facilities, and clearly that is not a pub brewery. So I think where a lot of the issues lie is that there is so much discrepancy in the way that the licenses are issued, in the way that they can be read, that there needs to be some kind of overhaul. So I'll ask Rob, how would you guys like to see those laws changed? And what are the drawbacks if you do stumble down the road of changing language in the farm brewery law? What could happen for the 91 farm brewery permitted breweries out there if they recognize something that maybe shouldn't be there?
I think this question has a lot of aspects to it. I think one of the reasons why the farmer brewer license has moved to the number one choice is the somewhat recent, and maybe 3 or 4 years ago, change that allowed farmer brewers to pour beer at retail in their tap room. That kind of elevated to the most popular choice. I think the word farmer brewer is totally a misnomer. We don't necessarily farm. We're open to changing that. That was thrown in there, I believe, because the wineries have a similar law. And I think what we really want is to make sure that we preserve what we have, all the jobs we've been able to create. For example, at Night Shift, we have 61 employees, and 31 of them work in our tap room. That's a lot of jobs that we want to maintain, and that's something I care a lot about. So I think our biggest concern is making sure we can somewhat maintain what we got going on, and then just making it clearer. I think one of the thrown around ideas is sort of a menu a la carte. Like if you want to pour draft beer, you do this. If you want to, deliver your own beer, self-distribute, you can do this, get this additional permit. And I think that would make it very clear of the levels of what you can do and how you want to own your business and operate.
And obviously you mentioned retail as a big component of that, but I think one of the other big components of the farm brewery permit is self-distribution. Bill, where does your organization stand on breweries being able to self-distribute, and do you guys feel that there should be some sort of cap put in place? If so, what would that cap look like?
Well, I don't know that there is a position that the beer distributors of Massachusetts currently hold in regards to that. We basically take the law as it exists now. It's very clear in its meaning, it's direct, with very distinct variations, one type of manufacturing license from another. Certainly the legislature has seen fit in many of these licenses, and indeed with every single manufacturing license, I think as Rob pointed out, to put certain restrictions on one type of manufacturing license and put another type of restriction on a different type of manufacturing license. As I said earlier, it all depends what type of business you want to operate, and that's going to drive the license, and each individual license has its virtues and its issues associated with it.
Sure. John, are the laws clear in Massachusetts as it relates to licensing?
Very clear. The farmer brewer really is in a golden age. It's $22 for a farmer brewer's license, probably the cheapest fee you can pay for anything in Massachusetts. And for that fee, you can self-distribute. You can self-distribute 50,000 gallons of beer a year, which is approximately 1,600 barrels or so, 31-gallon barrels. And there's very little pressure from the wholesalers when you're at that level. So you have very free range to distribute, self-distribute beer right now. With this coming task force, those laws might change. I think that the one thing the farmer brewers have going for themselves now is that there are so many of them. Bill Kelly was the advocate when he was general counsel for the ABCC, correct me if I'm wrong, Bill, of having a farmer brewer defined, or at least the ABCC tried to define a farmer brewer as somebody who manufactured 50% or something percent of the ingredients of its beer on the premise. There was a political firestorm. The ABCC backtracked. And from what I always tell clients now, it's don't ask, don't tell. You have to list your manufacturers, or I'm sorry, your suppliers, and you can include in your suppliers Massachusetts farms where you bring your spent waste. So long as you have Massachusetts suppliers and farms that you can provide your waste, you can become a farmer brewer without any evidence whatsoever that you are in fact a farmer. And I do think this task force is going to look at that issue. Why are we giving $22 licenses to farmer brewers who can self-distribute, go around the entire three-tier system for no real reason? I think that's going to be an issue in the future. And I think right now everybody that's in it, including Jack Zabby and everybody else that has a farmer brewer's license, may want to look towards the future and see what that may hold.
Right, and the 1,600 barrels of self-distribution, or 50,000 gallons more accurately, that's a tiny amount of beer in sort of the grand scheme of things. And there are farm brewery permitted businesses in this state that I would guess are producing more than that. And how they're distributing that beer, I'm not sure. But some of it may be going through their retail tap room, which I believe they can apply for, a farm brewery retail provision as well to allow them to sell that. But where do you guys stand on, both of you guys, Rob and Bill, on that 1,600 barrel cap for farm breweries? Is that a fair number? Should it be raised? If so, what's the proper amount to raise it to?
I don't know what the proper amount is. I know for our business, self-distribution was fundamental to our success. We started on a 3-barrel brew house. Our first year of business, we made 200 barrels of beer without self-distribution, we wouldn't be able to survive. I mean, we barely survived. I think I made $0 my first year. So I think it's important. I don't know what the right number is. I know there's states that have 25,000, 50,000 barrels as the cap. I don't know where the Guild sits. We haven't kind of come to that conclusion. But
Does the Guild have, or will the Guild ever have a unified voice on that front?
I think eventually we will, yeah.
Bill, how about your constituency and their thoughts on self-distribution and a cap? I know you said that they haven't really come out publicly with a position one way or the other, but it seems like the self-distribution does benefit these businesses quite a bit, as Rob pointed out, and oftentimes can actually lead into some built-in sales for distributors who may acquire those brands at a later date. So, will the Guild ever take a position on self-distribution?
Well, as I sit here, the Beer Distributors of Mass do not have a position on self-distribution as a general matter. Again, they focus at what the current law is, what the standards of compliance are, and basically review those. Any proposals of change will get reviewed. As a matter of general principle of self-distribution, I think in far as forging the genuine teamwork that is necessary for a successful brewery to build with a successful distributor, you should be schlepping 200-pound kegs down the rickety stairs into the cellar in the city of Boston. Because if you don't do it, whether it's for a summer job or for your self-distribution, I don't think you have the same appreciation as someone who has of exactly what it takes to distribute beer in Massachusetts across a broad, diverse geographic footprint, and all the costs that get associated with that and the capital you need to invest to do that well.
Chris, if I may, the 50,000 gallons do not apply to taproom beer. It's only sales to Section 12 and 15 retailers.
Yeah, there are certainly breweries that I think are farmer brewery permitted operations that are producing more than that amount, but likely going through the retail taproom, which.
And one more benefit of the farmer brewer's license is that they are able to operate taprooms like this outside of the Massachusetts quota that limits how many liquor licenses, pouring licenses a municipality may have. And I've seen, and we've helped quite a few brewers essentially open tap rooms as restaurants with their own brands, but not have to pay for the $300,000 or $400,000 liquor license that would come with a restaurant like this in a different city.
So you're saying the brewers have it pretty good?
I would say that the farmer brewers right now, under a long line of law, have it very well, and I think the farmer brewers should actually be out there and trying to protect the status quo.
So on that note, I guess, Rob, one of my questions going into tonight was going to be, what sort of legislative initiatives does the Guild have for 2017? Have you guys met to discuss what those may be? Certainly that may change now that we know a little bit more about what this task force is going to be looking to accomplish over the next year. But what are the legislative initiatives for the Guild, and have you guys discussed that yet? What might that look like next year?
Sure. As Bill Kelly mentioned, we have till end of January to kind of get something out on the table. The big thing for us, for maybe the 7th year in a row, is franchise reform. That's the key piece. There's some other bills out there that we might weigh in on, such as obviously licensing reform we would be involved in, and there's things like the growler bill and some of those other pieces that are floating out. But our main focus will be the franchise.
Sure. So let's jump into the franchise reform issue then. I moved here from California in 2000, end of 2010, early 2011. So as long as I've lived here, which is not very long compared to everybody in this room, this has been an issue that has been quite contentious. Wholesalers and brewers have always been in opposition to one another on how the franchise laws should be reformed, if they should be reformed, and if they were reformed, what that would look like. So I've been watching this, writing about this for 5 or 6 years now, and it's always been the 20% of a wholesaler's sales pitch that's been tossed out by brewers, claims of distributors not sitting down at the table to discuss the issues. So, with all that being said, essentially we know that brewers have been working to repeal some of the state laws. There's been strenuous lobbying efforts on both sides, but particularly on the wholesaler side. And it's been centered around the 20% of a wholesaler's sales. So why have craft brewers pushed for this kind of legislation, and why have wholesalers not gotten on board with it? So I'll start with Rob.
Sure. I think, to me, it comes down to common sense. Any business relationship in the state of Massachusetts is governed by contracts. There is no law to protect and hold people there forever. Whenever I talk about this to regular people, they're shocked that I could sign a contract, or I don't even need to sign a contract with a distributor, and no matter if I live or die, Night Shift is always going to be sold by that person. That just doesn't make sense. I've used this example before, but if I don't like my hop supplier, I have the right to leave and find a better solution. If their quality dips, if the supply dips, if it's not working out, I'm not getting the service I need, I can leave. That's sort of the fundamental basis, but there's a lot more to it, obviously.
Sure. Bill, have wholesalers had a conversation with brewers about franchise law reform directly, and if so, what was the result of those conversations?
As we have shared with many people in addressing the statement that the distributors aren't willing to talk, I think we distributed for all to see a clear timeline of, in fact, how many discussions and how long those discussions have been going on. And yes, they haven't come to a fruition in which there's supportable consensus achieved from both sides, but that notwithstanding, the conversation has occurred and it will occur. Certainly, my number is 617-523-3065. Call me on the phone anytime. My email address is bill@mabeerdistributors.com. Send me an email. We're not afraid to have a conversation with anyone.
Sure, but with all due respect, Bill, there were no distributors available for this panel discussion tonight.
I am their representative. I am the distributors personified.
Sure. How much beer do you distribute on a daily basis, Bill?
To myself?
So what we're dealing with here, I think, is an issue where you have brewers that are just looking to have a conversation, wholesalers who have said that they would actively engage in that conversation or have actively engaged in that conversation, and no progress being made. We're sort of at a point now where either the position needs to change, so either we strip down the 20% of a wholesaler sales issue, and we change the approach as brewers or as wholesalers. We agree that we're going to look into this. We're going to come to the table and have a discussion and talk about a way to move forward. Is that something that will ever happen? Will brewers and distributors ever find a compromise, find a middle ground here?
I mean, I sure hope so. I mean, maybe I'm young and dumb or live in like a utopian society in my head, but I think we're all on the same page. At the end of the day, we all want to just sell more beer and make more money. I mean, that's the game. Like, we're on the same team, but for some reason, we can't come to an agreement on the littlest thing. This is not like, the sky is not going to fall if we have franchise law reform. We are going to sell more beer. That's what we want out of this change in the law. I don't know what the percentage is or if there even should be a percentage. Personally, I think there should be no percentage. That is how DC operates, and they're still selling a ton of beer, and craft beer is thriving. Why can't that exist in Massachusetts?
Yeah, and there are states that have no franchise laws. There are states like Washington where it's a cap. 200,000 barrels. If you're under 200,000 barrels, you're not subject to the same types of franchise laws as other businesses. Is that type of reform something that the wholesalers would ever consider, Bill?
Well, I don't have a defined position on any specific proposals. The first I've heard about even throwing out that 200,000 barrels is when you were kind enough to share that in your preview of coming attractions questions. I do have to say that we don't need a table to come and have a conversation with our trade partners who are the breweries, both the craft breweries and any brewery. And I've said it before, I've said it consistently since I've been in this job because it's the truth. The beer distributors are the craft brewers' biggest cheerleaders. The beer distributors want your brands to build. That in fact, when you succeed, the beer distributors succeed and vice versa. It is an authentic partnership where both of us should be devoting our resources to figure out how can we get a better product to the consumer on a more efficient basis. And in fact, there was an eye-opening article just yesterday from one of the beer writers that basically said we have a beer category problem. Wine and spirits are basically eating the lunch of the beer segment. And instead of spending all our resources on these intramural disputes and spats, we should be combining together to face the real problem that was identified yesterday in a trade magazine and do something about the beer category together.
Sure. So with that being said, and knowing that there is this task force here in Massachusetts that is coming together that likely won't include individuals from either side, from the brewery side or the wholesaler side, is there an opportunity for brewers and wholesalers to work together to get out ahead of any sort of coming reform that could impact both tiers, negatively or positively, certainly? Is there an opportunity to finally work together and sort of cross the aisles and work together on some of these issues? And I'm kind of looking at John because you're right in the middle, but do you think beer wholesalers and breweries can finally work together on these issues?
Well, it's like a child between warring parents. I do think that this is the seminal issue that divides the wholesalers and the manufacturers. And I do think that the high-priced legal talent brought to bear from the wholesalers will put up a very difficult wall for the brewers to overcome. And I think you've seen that for years, and I think the brewers, if they're going to want to try and fight it out in the legislature, would need to hire lobbyists and fight it out in the legislature. Now, that may be the case, and that was sort of the case this July. It may be the case next July, barring a task force recommendation of the contrary, but it seems to me that you two are partners in this industry, and that it should be a mediated resolution to this particular issue, because it is an issue, in my opinion, and by the way, all my opinions here are my personal opinions. If I'm paid to advocate a different decision, I'll advocate a different decision, but it seems to me that there should be a resolution of this, what we call 25E franchise law restriction that prohibits even the smallest of brewer from ever terminating a wholesaler regardless of anything. And I know there are elements in 25E that you need to prove, but they're very difficult and they're very expensive to prove. And while you're trying to prove them before the ABCC, you have an order entered against you that requires you to sell to the old wholesalers. So it's a very particular problem emanating from the early 1970s Nixonian protectionist legislative era that I think should be addressed. And if you read the case law from 25E, it says that these circumstances where the 25E was enacted no longer exist. In 1971, you had big brewers, Anheuser-Busch, Miller, and you had small local wholesalers. Now it's the opposite. You have many, many manufacturers and very few wholesalers. So I think there's a lot of remedies, including litigation. Rob, did you ever want to go there? That you may want to try and resolve this issue. It is the seminal issue that divides this particular aspect of the industry. Otherwise, these two are great partners.
Yeah. No, I agree.
If I may,
Yeah.
just on one point to clarify Mr. Connell's comment, we don't build walls. The beer distributors build brands.
Fair. I think there are a lot of people in this room that would disagree, but how many brewers are here, by the way? Show of hands. Do wholesalers build brands? We'll toss that out. You guys, don't forget about the mic here. Don't forget about the mic. If you guys have questions, jump in. We'll get back to that. We'll get back to that. So we have obviously a very contentious issue here about franchise reform. Rob, I want to ask you, what types of brewery businesses would franchise reform most benefit?
I think it has the potential to benefit everyone. I mean, breweries need distributors. We need to get our beer to market. It's really expensive to do it yourself, even with self-distribution. I mean, for example, we have $300,000 worth of trucks. I would have loved to spend that money on more tanks like Jack's Abbey has behind me, but I didn't feel comfortable in the landscape signing or working with a distributor. I don't think it has anything to do with size. I think it has to do with if things go sour, that we have an opportunity to keep our brands alive and to keep the jobs that we've created going. There's plenty of brewery friends that I have that have gotten into relationships with distributors and they're not working for one reason or another. And what ends up happening is their brand either suffers or they send the beer out of state.
Sure, and there are plenty of examples of breweries that are working very effectively with their distributor partners as well. I guess my question really is, does size matter here? Would franchise law reform benefit the smallest breweries the most? And if so, why has it historically been some of the larger entities that have pushed the hardest for reform, specifically with regards to the 20% figure?
I mean, the largest breweries have the money to spend to help reform things. The smallest guys don't. In Massachusetts, self-distribution is a somewhat viable option for the short term. But if the relationship is really good and the distributor is holding up their end of the bargain, then it's a win-win for everyone. If it's not, there should be an exit. I don't care if it's Sam Adams or if it's the small guy down the street from us, Bone Up. Sam Adams is still one of the smaller breweries in the country. They only are 1% of the beer market. That's a very tiny amount of beer.
Sure. They also have a wholesaler's permit here in Massachusetts. I guess if they did want to do any sort of distribution or take that back at some point, the opportunity is there for them. I think we've sort of beat down franchise reform a lot tonight. If you guys have any questions specifically related to it right now, I'll go ahead and toss it to you guys. Otherwise, we can always revisit it towards the end of this panel. But if you guys have any specific questions with regards to the licensing or the franchise reform, go ahead and see Jackie in the back of the room with the microphone. Jump in there. Don't be shy. And we can ask that now. Otherwise, I've got some other topics that I want to kind of jump into. Obviously, we touched on it earlier tonight, but the pay-to-play activity that has sort of run rampant here in Massachusetts and reared its ugly head. John, what have been sort of the ramifications of pay-to-play in Massachusetts? What's the latest on some of those cases, and how disruptive was that for both breweries and wholesalers here in Massachusetts?
Well, for those who don't know, pay-to-play was the Massachusetts Craft Brewers Guild, a wholesaler, was accused of violating the law against price discrimination and inducements, and found to be in violation of our state law and our ABCC regulation. And they received a 15-month suspension, something like that, with 3 months to serve. So one of the largest craft brew wholesalers was going to have to close for business for 3 months. At the ABCC, there's a mechanism that you can get out of serving a suspension called paying a fine in lieu of suspension, which it's an accounting mechanism, but you can basically pay for every day that you were going to be suspended, you could pay the gross 50% of the gross profit and get out of the suspension, which is good for the employees. Obviously, if the Craft Brewers Guild were closed for 3 months, most of its brands would have gone elsewhere, or would have been entitled to argue that they were authorized to go elsewhere. So instead of serving the 3-month suspension, they paid a fine equal to 3 months, half their gross profit, which equaled $1.6 million. And ordinarily, when you pay a fine in lieu of suspension, that's the end of the case. In fact, they had a form for years at the ABCC when you signed it that said if you are paying the fine, you waive all rights of appeal. But for some bureaucratic reason, we don't know, you waived the appeal was disappeared from the bottom of the form. So they paid the $1.6 million fine and then appealed the decision to the Superior Court, where it's now sitting. The ABCC has tried to file its record. The lawyers are going back and forth on whether the record is complete. But when the record is complete, it will trigger cross motions, at which point a Superior Court judge will decide 2 things: whether they violated the discriminatory prices, which is I'll sell you a keg of beer for $20 and I'll sell you a keg of beer for $15, and inducements, which is a sort of a rebate. Interestingly, in this case, the craft beer wholesalers who have appealed are arguing that the anti-inducement rule is unconstitutional, it's vague, it's unenforceable, and they may have a shot at that. It's a very weird regulation that mirrored a state law that was repealed in 1971, and they may actually have a shot at repealing or invalidating that particular regulation, which is if I give you $1,000 to dedicate a tap line for this particular brand, I'll sell you that brand. So perhaps Bill can talk more appropriately on this because this is his bandwidth of clients, but if they are successful, the Craft Brewers Guild may have invalidated a law in Massachusetts against inducements, which means then we may be on the precipice of being able to have inducements in the industry. And I don't know how the brewers feel about that, and I don't know how the wholesalers feel about that, but if you can actually offer inducements to retailers to buy your brand of beer, is that a good thing for the industry or not?
Well, I guess I'd pose that question to Rob and Bill.
The jury's speaking after a quick deliberation. I am not involved in any of the six cases that are pending before the ABCC. One against the Craft Brewers Guild, as John accurately recited. That is a pending litigation in the Superior Court. There are also 5 retailers, I believe, summoned in for allegedly violating the inducement regulation by receiving the inducements. One retailer had the case decided, the other 4 are pending. So while I've been monitoring it with great interest as far as the questions of law, as well as the practices involved, I don't have any real comment on that.
Was it disruptive to your clients at all?
Well, anytime the ABCC takes adverse enforcement action, everyone stands up and takes notice. Just as I'm sure there was any number of conversations amongst the members of the Guild before Rob became president and probably even after, since the cases are still pending. So we're waiting to see.
Rob, what was the effect on breweries here in Massachusetts?
I think one of the biggest things is just we're all a little confused on what constitutes pay to play. Obviously, paying $20,000 to a bar is very different than some of the other smaller examples that exist in the market. But I know we can't afford to pay $1,000 per draft line. We wouldn't be able to succeed in the market, so we definitely don't want that. But I think the law is vague enough, and sort of what John's hinting at is, is giving glassware to a bar, is giving a tap handle to a bar, is that pay to play? That's something of value. I think what we would like to see is just clarity. What is okay and what's not?
Sure.
I think the best result of this lawsuit is when you give, there's immaterial inducements as bar handles and so forth, but inducements are still illegal at the TTB federal level.
Yep.
They're illegal in almost every state. The Craft Brewers Guild is trying to hold the inducements prohibition unlawful, and I think it's a big mistake. I think if they're successful and they're able to give inducements, I think that'll come back to haunt them. The only party that will make out on inducements is very strong retailers, restaurant groups of 10 or more restaurants, or liquor stores that have, Costco or Kroger's, and they have the volume where they can induce the inducement, whereas smaller retailers cannot. And the only money that's going to be lost in inducements is by the brewer, who's going to have to reimburse the wholesaler, who's going to pay it to the retailer. So I think it's a bad thing. I think with all due respect, Bill, I think the wholesalers should try and wrap this litigation up and leave that law intact.
Yeah, and potentially the world's largest brewery, Anheuser-Busch InBev, could benefit, specifically in Boston. I mean, somewhat vertically integrated there with ownership of a wholesaler as well as being a supplier.
Wholesalers have traditionally been against inducements. I think earlier this year, Kroger tried to get the
Category
manufacturers to, in order to sell to Kroger, they wanted shelf display services, which then the Wine and Liquor Wholesaler Association went to the TTB and complained. And they said, we don't want inducements. We don't want to have to give in to this very powerful retailer. And I think that's indicative. And then you have, interestingly, this Massachusetts wholesaler who's trying to say inducements are legal. So it's, I think you got to be careful for what you wish for there.
Yeah, definitely. One final question on the pay-to-play. Has it tarnished at all the public opinion of beer, of brewers, of wholesalers? It's something that's been written about quite extensively, and that people are becoming more and more aware of. The average drinker is becoming more and more aware of. So has it tarnished at all the public opinion of beer here in the state?
I don't know if I would say tarnished. I think it maybe opened people's eyes a little bit to what happens behind the scenes. I think craft beer has that great sense of community. We're all in this together, and getting exposed to a little bit maybe of the darker side was eye-opening. But I think we're still in a good position with consumers.
All right. One final question before I turn it over to you guys. Marijuana. Yes. Is it 420? It's 420 somewhere. It's 428 somewhere, actually. So, question 4. Obviously, election's coming up. I'm just sort of curious where we think this will go in Massachusetts. Question 4, for those who aren't familiar, marijuana legalization. Obviously, it's been decriminalized, and medical marijuana is legal, but recreational legalization is what's on the ballot this year. Massachusetts certainly isn't the only state where this is occurring. A lot of talk about how marijuana consumption will how it will impact beer consumption, or I guess total alcohol consumption is a better way to put it. So I'm curious for your thoughts. How will marijuana impact beer consumption specifically? Will it have a negative impact? Will it have a positive impact? And where do we think legalization in the state of Massachusetts will head next month.
The Guild definitely doesn't have a position on this, but I think the jury's kind of still out whether it'll have any impact on alcohol sales. I think we've seen in Washington and Colorado that it doesn't appear to have any effect. Craft beer is still going strong, and people are still drinking as much as they used to. I think it's kind of a wait and see for us.
Sure. Bill, your organization contributed some funds to an anti-marijuana legalization campaign. So it would seem to suggest that you guys are against this type of legislation. Any particular reason why?
Well, it is an accurate reported fact that we did make a contribution to the opposition group that was formed. But we do not have a position, a public statement or explanation of our motivation or inspiration for that. Certainly, the news reports every day the many, many questions that are raised by the overall question that the voters here in Massachusetts will decide on November 8th. I'm monitoring it from a personal perspective. I have many nieces and nephews who are at this stage in life much more mobile and on the road than I am, and I have concerns for them.
So you're not in favor personally of any kind of recreational marijuana legalization here in Massachusetts?
I haven't come to my personal choice yet, but certainly there are any number of recent stories and reports, as well as the pre-existing unanswered questions presented by this ballot question that I haven't resolved yet.
Sure. John, I don't know how closely you've been following it, if you have at all. Do you have any sense or temperature check on what the likelihood of marijuana legalization passing in Massachusetts actually is?
Well, my connection to marijuana is purely personal and not professional, number one. I may profess a desire to have it available and not get arrested and so forth. As far as its effect on the industry, I understand Bill's group has opposed it. I understand other groups, other alcoholic beverage groups have opposed it.
Sure.
I'm pretty familiar with marijuana, and I think marijuana and alcohol can coexist, is my personal opinion. How it's regulated remains to be seen. I think you could use the ABCC or a similar board, the cannabis board as they're calling it, and lawyers like me who are interested in making sure everybody does everything the correct way could make money on that. But on a certain level, I do agree with Bill that it is kind of sad to think that younger people might be exposed to the availability that obstacles that Bill and I had to overcome.
All right. That is a fair answer, John. That was a very honest answer. All right, give it up. Give it up for John. Well, that was certainly all the questions and all the topics that I wanted to get to. I don't know that we've solved anything tonight. Actually, I'm positive that we haven't solved anything tonight. However, I do think it's at least a positive sign that I was able to get you two folks up here and John as well to sit between you guys, I guess, and make sure that you guys didn't take off the boxing gloves or anything. But thank you again for joining me. Like I said when we started this, the whole goal is just to have open and honest dialogue. I think it's important that brewers and wholesalers get together and talk about these issues. At the end of the day, I'll quote my good friend Andy Thomas from Craft Brew Alliance, who says that beer is your last name. So whether you're craft beer or just beer, beer is always going to be your last name. And I think it's important that we discuss this stuff and we get together on this stuff. So thank you, and thank you everyone for coming out tonight. Cheers. And thank you to Jack Sabby and all the folks behind the bar for pouring beers all night. I think Sam was a little bit shocked or surprised that we had 100 plus people coming tonight. So I'm sorry if we totally overran your joint, but thank you again. And a big thank you to all our sponsors for supporting us all year. This is our final stop of 2016. Let's drink some beer. Cheers.